And yet that is the test that to this day is applied when you're challenging a law that restricts your economic freedom. So to go back to my pigeon case, we filed this lawsuit that says against this law that says you have to study for 2 years before you can put spikes on a building. You're not using pesticides. You have to study pesticides for 2 years and take this examination, get a criminal background check, all this stuff in order to put spikes on a building. And you don't need that license if you put spikes up to keep seagulls or starlings or something or bats away, right? So we file our lawsuit and we say this law does not have a rational relationship to a legitimate state interest. So I'm there in deposition. I have the state's expert witness in there in deposition. And this is the guy who basically wrote this law. So I said to him, I said, so now, this law says you have to have a license to put spikes on a building to keep pigeons away. He said, yeah, that's right. I said, but you don't need any license to put the same spikes in the same building to keep seagulls away. He said, that's right. I said, would you call this irrational? He said, yes, I would. And the government's lawyer says, can we take a break? So we come back from the break, and he says, I'd like to clarify what I said about irrational. I'm thinking, I bet you would, right? He says, what originally happened was originally you needed a license for all pest control work. And then in the 90s, they were considering eliminating that requirement if you didn't deal with pesticides, because you weren't a threat to the public if you're not using pesticides, so why need a license? But those of us who already had licenses, we didn't want to face competition from newcomers. And so we went down to the state legislature and said, could you divide up the market and let us keep the most common pests, like pigeons? And then these guys, they can deal with the other pests, and we don't care. And I'm saying, please tell me more, right? I always tell law students the hardest thing in a deposition like that is not going, aha, got you. Right? You have to go, I see. Right? So we go to the court, we go to the trial court, we say, Your Honor, it is an undisputed fact in this case that this law is irrational. And we still lost. Because the rational basis test tilts the law so dramatically against businesses and property owners. That's how bad it is. What the judge said was, yes, it's true, the state's rationalizations for the law make no sense, but I can think of a way it might be rational. And that's actually what the courts do in these cases. Not only can the state make up its own irrational justifications for these laws, but the court can come up with its own justifications for the law, even if nobody ever said that when the law was passed. Right? Now imagine that. Imagine that were the rule in criminal law. Imagine you were brought up on criminal charges and the prosecutor failed to prove the case. And the judge said, well, it's true, the prosecutor failed to prove the case, but I can think of a way you might have done it. That's really the law that applies when you're dealing with your constitutional right to earn a living, a right that has been protected by Anglo-American courts for 4 centuries. Now, I'm glad to say that when we appealed that case, we went to the Ninth Circuit Court of Appeals and the court overruled that case. And they said, the state is only using the law here to protect established businesses against fair competition, and that is unconstitutional. So I'm glad to say that we were victorious in that case. But that's only the second court ever to say that. There was a court in Tennessee, the 10th Circuit Court of Appeals, I'm sorry, the 6th Circuit Court of Appeals, invalidated an occupational licensing law for the same reason and said government cannot use these licensing laws simply to protect established businesses against fair competition. But the 10th Circuit Court of Appeals, right here in Colorado, the 10th Circuit Court of Appeals, in an almost identical case, said yes, government can use occupational licensing laws simply to protect established businesses against fair competition, even if the law has no connection whatsoever to the general public. That was a case called Powers versus Harris, which is still on the books today and has not been reviewed by the U.S. Supreme Court. I think that that was the worst decision on economic liberty since the New Deal, and possibly ever. Because that law says that the legislature can hand out economic favors or any other kind of favor to one interest group at the expense of another for no reason at all. In other words, arbitrariness and law are the same thing. Government has no requirement. Government is under no duty to abide by lawfulness. It can act arbitrarily if it wants to, and courts will do nothing about it. That's the law in Colorado today. Now, there's another case that I'm working on right now, because this issue over whether protecting an established business against competition whether that is a legitimate state interest, that is a very important issue in American economic and legal history. And I'm working on a case right now, just filed it a month ago in Missouri, where I represent a guy named Michael Muni. He runs a moving company. Well, in Missouri, if you want to run a moving company, you're required to first get permission from all of the existing moving companies. What happens is you file your application for a license to run a moving company, and the state notifies all the existing moving companies and allows them to object. And if they object, you are required to prove to a group of bureaucrats that there needs to be a new moving company. Now imagine that it were, let's say, I think it was 1993, I think was the first time I ever went to a Starbucks. I was in Seattle. A friend of mine said, you got to try this new place. It's called Starbucks. It'll take the world by storm. Now, if 1993, if you had been forced to prove to the world that there needed to be a new coffee shop, how could you have done that? There's plenty of coffee shops, right? Not only that, but the Missouri law doesn't provide any standards of evidence or procedure or anything for how to determine whether there needs to be a new moving business. So we filed that lawsuit. The state has moved to dismiss that case, and we're opposing that motion. In fact, we're filing our opposition tomorrow. About 2 years ago, we filed an identical case in Oregon. That state had the same law. Moving companies had to get permission from existing moving companies. And I'm glad to say that after the court refused to dismiss the case, the state legislature said, this isn't worth it, and they repealed the law. And that was a year ago. In fact, it was a year ago this month. And in the year since, there have been 20 new moving companies that have opened in Oregon since that time. Now, when we filed the case, there had not been a single new moving company allowed to operate in Oregon for 2 years. Now, who should decide whether there needs to be a new moving company in Oregon or Missouri or elsewhere? Bureaucrats or consumers? Exactly. What economic liberty does, economic liberty is the principle that these decisions should be made by consumers and producers, bargaining between themselves, and not by bureaucrats who are swayed by political interests and lobbying and other things like that. Now, these are a lot of fun. When I talk about these cases like the pigeon case and the moving case, these are fun cases, right? But they have a central philosophical point that's very important, that's crucially important. And that is that the government is supposed to abide by principles of lawfulness. It's supposed to respect our individual rights, including our right to make our own economic choices for ourselves. When the government deprives us of those rights in the service of a private interest group, it is acting arbitrarily, contrary to centuries of Anglo-American common law tradition and contrary to the principles of the American founding. Now, I love my job. I sue the government for a living. It's the greatest job in the world. Really, I mean, my day is not complete until I've made a bureaucrat squirm. Okay? But you're not going to change the world just by suing the government. What changes the world are philosophical ideas, principles. The progressives started out in the 1880s trying to change the world, and it took them 50 years. It wasn't until the 1930s when the Supreme Court started using their ideas to curtail our economic freedom and give government the blank check to do what it wants. For those of us who believe in individual liberty and economic freedom and free markets, it's a long road ahead of us. And it's a road that has to be brought not only in courts. We don't have to just bring these arguments in courts. We have to bring these arguments philosophically to the general public. We need to, you in the audience, need to learn about these principles, study them, and talk about them. Talk about them to your neighbors and your friends and your children and your grandchildren, because that's how change really works in the United States. That's how change really works in the whole world. Courts are the trailing edge and not the leading edge of culture. And culture has to change. We need to restore respect for America's wealth creators. So that's why I'm so glad to be part of this meeting tonight and to be joining forces here with the Independence Institute, because they talk about the principles that are involved. Those principles need to be vindicated in court, but not only in court. They need to be vindicated in public policy, in how we vote, in how our government works across the board. So when you go out tonight, I hope that you will keep in mind that these four great progressive ideas, that rights are just permissions, government exists to make society nice, that courts shouldn't be involved and should stand back and let legislatures do whatever they want, and that the Constitution changes to meet the changing needs of the day. I hope you'll be willing to stand up and challenge those ideas in public, in the courtroom, in the classroom, and wherever you happen to be. Thank you very much for having me on.
Thank you.